Hello there, my name's Adam Topham and I'm a freelance contractor in the UK. I have 15 important points to walk you through that will demonstrate why we all just need to fix the tomato. Point 1. From April 2021, our clients will be liable for the determination of inside or outside IR35. Point 2. HMRC will obligate them to assess the engagements with reasonable care and have provided a substantial volume of materials on their Check Employment Status for Tax or CEST site to guide as to what represents reasonable care. Point 3. Any dispute HMRC raises with clients will no longer be focused on the actual status conclusion of inside or outside IR35. Instead, they will challenge the client process in order to prove a lack of reasonable care. HMRC likely won't bother to even challenge inside IR35 determinations because they have nothing to gain. If they successfully challenge reasonable care in an outside IR35 case, clients are liable for uncollected tax and national insurance, with additional penalties that could double the amount. Point 4. Clients will need to produce a status determination statement or SDS for each engagement. Point 5. HMRC does allow for a bulk or standardized approach to generate SDSs for groups of multiple contractors if working practices and contractual terms can be sufficiently aligned. Point 6. Clients who employ scores of contractors will want to take this bulk approach for efficiency, reliability, and a reduction of compliance risk. Point 7. That means they will essentially choose between either inside IR35 or outside IR35 when they determine their standard SDS process and outcome. Point 8. The main factors that will drive their decision are, firstly, a probable total lack of understanding of the facts and implications. Secondly, fear of exposure to substantial financial liabilities, fear of being involved in another damaging public tax avoidance scandal. Thirdly, many may see it as just not their problem. They won't have any reason to understand the crippling and profoundly unjust impact upon contractor take-home pay and financial flexibility. Point 9. What that means is that minimally considered immediate reactions from clients is that inside IR35 is preferable, driven by fear and a lack of understanding. Point 10. Somehow we need to educate clients that inside IR35 also comes with financial risk. They're liable for unpaid tax and national insurance for inside IR35 if the deemed employer and fee payer further down the line fails to do so and HMRC can't collect it from them. They will also suffer a talent drain or be forced in any case to pay out extra money to retain talent. They won't be aware that HMRC themselves engages hundreds of contractors outside IR35 because otherwise they cannot source the talent they need. Point 11. You will hear over and over again from IR35 lawyers, other subject matter experts, and thousands they have influenced that IR35 status determination is a massively complex soup of a multitude of unnavigable factors. What they won't tell you is that it is in fact tomato soup, and that if you saw the tomato, the salt, the pepper, the basil, the croutons do not matter. 12. What's the tomato? It's right of substitution. Clients, HMRC needs you to reject the tomato, but you don't need to. I'll share 2 facts in support of this. Fact 1. There are 36 contractor appeal case histories in the public domain. Contractors won 19, 10 of whom had strong rights of substitution. The other 17 lost their appeals, and guess what? All 17 of them had rotten tomatoes. Right of substitution weaknesses exposed. Now that's a pretty firm indicator that with a bulletproof, unchallengeable, evidenceable right of substitution that ticks all of the HMRC process prerequisite boxes, you won't lose, possibly even can't lose. Fact 2, CESTS is HMRC's designated free of charge assessment tool. This tool weights right of substitution precisely aligned to the case law results I described with regard to the right of substitution. If you fully accept the right in CEST, it is impossible to render an inside IR35 determination, no matter how you answer any and all of the remaining questions. The result you will unerringly get from CEST is that off-payroll rules do not apply. The reason you will be given is that answers told them your client has accepted or would accept a substitute, has accepted or would accept, no difference. Hence, I keep emphasizing you don't have to use the process. You just have to sign up to the fact that you would. HMRC cannot force contractors to not turn up. Neither can they force clients to provide holiday or sickness cover. Point 12, clients. What this unequivocally means is that HMRC needs you to reject right of substitution. And that's precisely why the questions are worded in CEST to incite you to do so. Point 13, contractors have by far the most to lose from the demise of outside IR35. Many we've spoken to feel powerless to do anything to save it, to influence giants like HSBC, Unilever, GSK, Deutsche Bank, RB. But companies don't make decisions, people do. And people can be talked to, they can listen, they can be influenced. That's why we have to start right now, all of us. Okay, it's going to take time. If we don't start acting right now, we'll be far less effective. We need to start to talk to our sponsors, urge them to talk to the right people and get them to properly educate themselves. Point 14, I've launched a company called 34 Square. We're building a freelance hub as a platform to turn thousands of limited companies into one virtual powerhouse. We provide a range of services to drive an outside IR35 determination, focused around, guess what? The tomato. Fix the tomato. HMRC needs clients to reject the tomato. Clients, you don't have to. The weighting of our focus is aligned with the case law and with HMRC's CEST tool when it comes to the right of substitution. It needs to become the industry standard right of substitution. We do tick all of HMRC's boxes for beautifully ripe tomatoes. We provide the capability to generate legally binding contracts between the main limited and the substitute, protecting the substitute, the main contractor, and the client in terms of overall contractual integrity and continuity. There's a right of substitution declaration directly between you and your end client, linked to the capability that we provide, which also helps to demonstrate that your client has taken reasonable care. Point 15, as contractors have by far the most to lose, we're hoping you'll see that less than £4 a week is a sound investment to drive the preservation of a thriving outside IR35 service delivery channel, something that 34 Square is passionately committed to. Contractors, if you care about saving outside IR35, come and join us for less than £4 a week and spread the word to contractors and clients alike. Let's fix the problem and not throw in the towel. If you want to know more about us or about IR35 in general, please don't hesitate to reach out to me, Adam Topham, on LinkedIn or via the contact form on our website at www.34square.com. If you can connect us with your client directly so that we can properly explain, we would be delighted to oblige at no charge. 34 Square is pushing for no rain and lots of sunshine in outside IR35's future. Because let's face it, umbrellas are such an inconvenience. Thanks very much for listening, and bye for now.